This is a totally completely different issue, but they need to change 16.1. But go ahead.
All right. 16 is now set.
All right. Good morning to everyone.
Good morning, Your Honor.
Let's go ahead and set forth our stances.
Will Kemp, Plaintiffs.
Joel Odou on behalf of Real Water Inc., AffinityLifestyles.com Inc., and Real Water Gold Coast.
Good morning, Your Honor. Jim Neale and David Spurlock for UNFI.
Good morning, Your Honor. Scott Rasmussen, of Hanna Instruments, Inc.
Good morning, Your Honor. Rob Robbins from Milwaukee.
All right.
Your Honor, Mr. Odou and I have figured out how to handle this.
Yes, Your Honor. The agreement's going to be reduced to writing. We'll hopefully get it circulated either today or tomorrow as to the stipulation on medical causation, and that the only issue is for damages for the jury.
Okay.
That applies to 7.5.
I understand.
Yeah, this applies to AffinityLifestyles.com Inc. and Real Water Inc. Real Water Gold Coast is not part of the stipulation.
Okay, here's my next question. And I always get these marching orders when I come in here from my staff. And let me see here. We have a letter from Mariah. I'm sorry, email from Mariah from yesterday. And she wants to know, what do we do for Tuesday? That's the bottom line. Doesn't this impact our whole process as far as the length of the trial right now?
As I said yesterday, Your Honor, we're going through the witness list and trying to cut a couple things out. And Mr. Parker and I are going to, we've scheduled a meeting for Saturday, spend 2 or 3 hours doing that. But my initial reaction is this would probably cut the trial back at least a week.
Thanks. I was thinking more than a week.
Well, just this, I think the court's rulings have, on some of the expert issues have cut it back.
Yeah.
Yeah, we would agree, Your Honor. If there was a need, depending how far we get today and depending on what issues are left, if there's a need to bring that, but certainly we don't want to be the ones delaying the case.
Okay.
Judge, I can live with Wednesday, given that it's the day after 3-day weekend too.
Let me see here. Let me read this.
I can live for Tuesday too.
Either way.
Yeah, I don't need to get involved with your discussions or anything like that. I'm just looking at it from a management perspective. Yeah. So, I mean, Wednesday's fine. Wednesday afternoon's fine. That gives us more time to do what we have to do, right?
Wednesday afternoon, fine with me.
It's fine with Real Water, Your Honor.
For no objection.
No objection, Your Honor.
Okay. I'll be right back.
That would be the first of the whatever 66 jurors.
Right.
Wednesday afternoon.
Wednesday afternoon. Okay.
All right. So I guess we can continue on. So we'll bring him in Wednesday. So we'll have a little more time.
1:30, Your Honor.
Yes, 1:30. And I just want to make sure I'm clear. I understand. What do you anticipate the time for trial is going to be now? I'll just ask that question.
I would guess 3 to 4 weeks, Your Honor.
That's what I'm thinking.
The court mentioned before that the 6-week estimate sounded to it more like 8 or 10.
Right before.
I agree with everybody that the court's rulings and Real Water's conditions or concessions or planned stipulation save time.
Right.
I wonder if we haven't gone from 10 weeks to 5 instead of 6 to 3. But
I understand. I do. Well, and my only point is this. You can think about it. We don't have to make a decision right now or even until probably 1:15 on Wednesday. And the reason why I bring that up, because as I go through the Woodard process,
have to tell.
got to tell them, right?
Right.
Yeah, what we anticipate the length of the trial will be. So you can work on that. So I wouldn't worry about that right now. But I want to make sure we have a true estimate, because that's going to go to the hardships and all those things.
So I'm sorry.
I was just going to suggest that if we're all going to be putting on our thinking caps over the weekend, if the that we've already disclosed changes, maybe we can agree to inform each other of that. Because that might, if we've taken a lot of names off that list, we'll have a better idea of the accuracy of our estimates.
Well, I know this for sure. The time period will shorten, right? And we know that for sure. How much, I don't know. That's more up to you. And just as important, from my perspective, it doesn't matter. I just want to be able to give the jury an accurate estimate. So when we go through the voir dire process, we can drill down a little bit.
So the question I had, and I'm sure it's been something that's already been said, and I apologize for asking the same question. Assume for a second that in my mind, I'm thinking 5 weeks now, and it could go shorter. It really depends on how long we have for days. If I recall the court's calendar, Monday, Tuesday, Wednesday, Thursday, Friday, full day on Friday, as I recall.
Full day on Monday.
Full day on Monday, Tuesday, Wednesday, Thursday, half days, right? Am I wrong on that?
Well, not half. Well, it varies depending on my calendar. Sometimes we'll start at 10:30. Sometimes we have to start at 1. Yeah.
Okay. So assuming that do at 10:30, which really means by the time we get everything set, then we have to go to lunch an hour later. I'm not sure, but those half day ones are the ones that got me in my mind thinking, yeah, probably 5 weeks.
Yeah.
Because I don't want to lie to the jury, and I don't want to say, oh, it's only going to be 3 weeks, and guess what happens? It ends up being 5. And so rather caution them on something that we have a lot of stuff that has to go on, a lot of different witnesses. The witnesses I've got, I think, will take 3 days.
I understand. But it's something we don't have to have an exact time frame today. You can work over the weekend or Monday,
Right.
or even Tuesday on that issue. I just want to make sure that when the time comes and we bring the 66 or whatever we bring in on Wednesday, and as I'm going through the general voir dire process starting off, that I can give them a reasonable time period, or a realistic time period.
Okay.
That's all I want. All right, so that's going to be done. Anything else on that issue, Mr. Odou, gentlemen?
No, Your Honor.
Yes, sir.
All right.
Mr. Rasmussen, maybe, the court may have some rulings.
Oh, I just love that. They want to know estimates. How long is voir dire going to take, do you think? I figure all of next week.
I was
Probably
hoping I was hoping we'd get it done by the end of next week, but I think we're going to add at least next Monday, maybe Tuesday. Your Honor, it all depends on the panel. If we get, if the first they walk in and they're perfect for everybody.
I'm anticipating 5 days. Anybody object to that?
Yes, sir.
No.
All right. Okay. And I wanted to go back to and circle back to motion was there. Defendant Milwaukee Instruments. No. Apologize. Defendant Hanna Instruments. Motion for partial summary judgment to dismiss the punitive damage claim. And I don't mind telling you this. I looked at this and I thought about it, and I understand what the facts are as far as this case is concerned. And I understand we have a conditioning kit. And I went back and I read Wyeth, and I understood specifically what Justice Cherry ruled, and I understood what the issues were there as far as Europe versus America and what was contained in the warning and inserts. What I don't know is this, and I'll just be candid with everyone. I understand we have the conditioning kit. There's issue in the conditioning kit they were in possession of, right? Okay. The thing about it, though, is this, and this is, I mean, I don't know the answer to this. I don't mind saying it. And typically, I don't grant summary judgment unless it's really clear, right? No questions of fact as a matter of law and so on and so on. We all know what the standard is. But when did they stop selling the conditioning kits?
So The retail, according to Mr. Kemp, is in 2017 is when they stopped manufacturing them. Not necessarily true for the United States to when they can sell them, because that was a European thing. The important thing is that those kits can be used all the way through 2020, were being used through 2020. He says that maybe they went old and stale. They don't. It's an inorganic material, those chemicals, so they don't spoil. So they're used through 2020 and they can be reused.
But that's not really,
But you asked, when did we stop selling them?
yeah.
Okay, so we couldn't sell them in Europe in 2017, at the end of the year 2017. The first case that we have is in 2018, 2019. They're still using these oxidation kit. It's there. It's reusable. You saw that language. It's there. So we can reuse them. And it appears that they were using, we're only talking about 2 years. It's just not that much time.
But I'm looking at, this is the issue. I mean,
This is a punitive, it's not a motion for summary judgment with regard to, if you put an instruction out there that somehow they didn't have this. It's not summary judgment on that per se.
no. This is what the issue is. It focuses on the product warning and whether it was inadequate as it pertains to the product or the probe itself. That's the thrust. I get that. And I understand what Wyatt says, but, and this is what is unique about this case. They had a conditioning kit in their possession. I got screenshots. I looked at it. I can't understand what it says, but this is what I don't know. And this is what I really don't know from a question of law perspective, because their allegation is essentially this: look, Judge, when they sold the product, they hadn't changed the instructions for an extended period of time. There's no warning there as to how to use this product under certain circumstances. As a result, potentially, if you apply Wyatt, they should be responsible on the hook for punitive damages. Your position is, well, we included it in the conditioning kit. They would buy it, but they stopped producing it. There can be questions as to whether or not, okay, if you had a conditioning kit, but if you stopped selling the conditioning kit, you should have put the same warnings into the retail packaging. I get that. But here's my point. We're asking for summary judgment. And for example, whether they had their conditioning kits in their possession, potentially with a similar warning, is that a defense or not?
And the warning.
Right? You see where I'm going on that?
No.
Right?
Okay.
No, but see, here's the thing.
Uh-huh.
You got to understand this. Just because instruction at trial. And I think what we need to have is a little bit more drilling down on this issue.
Okay, that's easy for me to do during trial. That's
Right?
easy, yeah,
That's,
Yeah.
I think that's the fairest.
so if you're holding it in abeyance, for lack of a better word, until then, that's fine.
Right. Well, yeah, I mean, and it's not even, I can't hold it in abeyance because I can't
Right,
lose.
right.
What I'm doing is denying it without prejudice.
Okay.
And then I'll make a determination.
Rule 50 motion.
Yes, I understand. Rule 50, I know.
Yeah, but
I'm
my
right.
point is, I
Yep.
have to see where the chips fall before I make a final determination on it, because I don't know what the answer is as far as having the conditioning kits in their possession.
Which and that's a fact. We found them at their facility. That's not in
Yeah,
dispute.
but there's other facts that you might develop.
Okay, fine. I will live with that.
Yeah,
That sounds, so with that, do you want to go on to the next one, or?
let's go to the next one.
Okay, because you just ruled that way, I have to go to two that I wasn't gonna have to go to, now I have to.
That's okay.
Okay, the first one is going to be our motion to eliminate number 3.
And motion in limine number 3 is?
It's, one moment, please, I'll get you the exact,
Thank you, Tori.
Hanna Instruments.
This is when I really need assistance, right?
Exclude expert report of Mark Rich.
Okay.
Okay. I'll try to make this brief. Blaze retained a CPA by the name of Mark Rich. Mark Rich put out a report. We don't believe it meets the standards under Hallmark and NRS Chapter 50 with regard to him being an expert in this case. We don't believe it assists the trier of fact as required under Hallmark. Let me explain the circumstances. The general manager president of Hanna Instruments was deposed by Mr. Kemp. In that deposition, he said the value of Hanna Instruments, Inc., a Rhode Island corporation, is $18 million. Mr. Rich's report says nothing about that. He never reviewed the tax records, which we did provide and were reviewed by plaintiff's counsel. And he wants to suggest that on a punitive basis, that it's okay to go after $500 million in punitive damages in the case. Remember what I said, that the value of Hanna Instruments, Inc. is $18 million. Okay? The Nevada is very, I'm looking at page 9 of my motion. Nevada law prohibits punitive damages that would render a defendant insolvent, citing Humana Inc. versus Forsyth and Nevada Cement Company versus Lemire, 1999 case and 1973 case. So the punitive damage allowance should be in an amount that would promote the public interest without financially annihilating the defendant.
And I do understand the annihilation issue. I do. And then you have another companion case. I won't call it a companion case, but you also have the limitations that were set forth by the U.S. Supreme Court as it pertains to punitive damages. And I think, was that the State Farm case? Yeah, State Farm case. Yeah, there has to be a relationship, and it shouldn't exceed 10 times. I get that. And I'm just saying in the general sense.
So 500 million would exceed that amount. So I don't know how the other thing is that he didn't do is he doesn't relate it, and we put this into our moving paper, and the court, if it's had an opportunity to review that, and if it hasn't, I know the court will, and we'll get some sort of a ruling between here and next week, Wednesday, with regard to this. You have to have something that's under Hallmark, right? Reasonable methodology. He basically says, and this is companion to our motion limit number 4, says, well, what I'm going to look at is every one of the Hanna companies across the globe. And I think collectively they might be able to do that. And then when I drilled down on it, I said, well, what specific financials have you looked at? And he goes, well, I've looked at one company, the Hanna Romanian company. And I said, well, the Hanna Romanian company is not a party to this case. Well, what about the parent company? I said, the parent company as an alter ego is not a party to this case. The only entity that is Hanna Instruments, Inc., a Rhode Island corporation. So whether or not someone else makes money is not relevant to any analysis that Mark Rich can provide to the jury, because if you're going to talk about other companies that are not parties, the amounts of money they make cannot be used as evidence of we should inflate this because other companies that are related to this make money. You should also know that the parent company for Hanna Instruments SRL, the Romanian company, is not owned by the same parent company as Hanna Instruments Inc., a Rhode Island corporation. Therefore, the two are mutually exclusive. They're just in the relationship of buyer and seller. In other words, here's a product that's in the distribution to be sold. Okay? So in that regard, we don't believe that Mr. Rich's report and him as an expert can be used in this case, because his whole analysis is based on this theory that all of the Hanna Instruments are there, and he doesn't have an opinion that it should be somewhere around $18 million and not exceed that, because it would annihilate the company. And that's basically in the holdings of the cases that we provided to the court. With that, Your Honor, this would be a short motion. That's what I have. And by the way, that can be for number 4 if you want to, with regard to conglomeration. The conglomeration theory that he has is that all of the Hanna Instrument companies from wherever across the globe, he said this several times in his depositions, they should all be there. They should all have their money up on this one. And I'm like, but they're not parties. Well, that's for something for the court to decide whether or not it should be there. So now it's up in front of the court. We teed it up for him. Can non-parties have to pay a judgment of a punitive award if they're not actually a named party in the case? According to the holdings that we provided for you, the answer is no, they cannot. Thank you.
Thank you, sir.
Your Honor, on punitive damages, this goes back to Ace Trucking. Ace Trucking was the first Nevada case that said you cannot have punitive damages that annihilate a defendant. That's the term. That's where that term came from.
Understand.
And you know, they cited Humana versus Foresight. That was my case. I don't remember that being an issue there, because it was. You know, there's a number of Humana Foresight opinions because we went up to the Ninth Circuit twice. We got Supreme Court opinions. And there's just, so I don't know where that's coming from. But the general rule is that a defendant can plead annihilation as a defense.
Right.
It is not for the plaintiff to overcome the fact that they can annihilate it. What they should have done is pleaded as defense. First of all, they didn't plead it as defense. So that's the first problem. And since they didn't plead it as defense, they didn't really provide credible evidence about what they could or they couldn't pay. And by that, I mean they provided evidence related to Hanna US. They did provide that, but they did not provide any evidence that would allow the accountant, in this case we've hired, to analyze what the conglomerate's worth. So it's a privately held enterprise. So all we know is it's a privately held enterprise. I mean, we asked the questions of everybody we could. What's this conglomerate worth? No one had an answer for us. No one knew. I mean, they couldn't even tell me whether, in the deposition testimony, can you even tell us whether it's worth $500 million? They could not give me an answer to that question. So the way we structured Mr. Rich's opinion is that they have not presented credible evidence that he's able to analyze whether or not they can afford to pay $500 million. That's the way his opinion reads. And we think that is as close as we can come based upon what they've given us. And again, like I said before, this is a defense. So we don't bear the burden of proof on this. Now, the real issue here, I think, is the conglomerate versus sole entity issue. And before I get into that, Chris, can we have the conglomerate chart? Because this is just one page of the conglomerate chart. Okay, there we go. This is just one page of the conglomerate chart with 32 entities. There's another one that has, where's the other one, Chris? Can you pop that one to show judge? There's another one, and then on top of this, there's another, see where it says 64 entities? So you have to add the 32 plus the 24 to get 64. There's about 110 different Hanna entities out there, all right? Why they do this has never been made clear in the discovery. I asked them, are you guys doing this for tax reasons? Is there some labor law in these European countries? Why so many corporations? And, it was unbelievable. The plant itself in Romania, they must have had 35 different entities, Hanna entities, working on this meter and other products. It seemed to be they just didn't want to get over, I can't remember what the measurement number was, 9 employees or 8 employees. So there must be something bad that happens under Romanian law if you have 10 employees. But whatever the reason, which they never explained, they've got all these entities. I've never really seen an organizational chart like this before. So during the discovery, we knew we'd be here. And so we asked, what is all this together worth? And the best we could determine is that they were doing gross sales. First they told me the gross sales were 800 million a year, then it went down to 600, then it went down to 500. And I think where we left it with them was 200 to 400 million of gross sales a year. And then we went, this is for all the entities. This is not just for Hanna US. And then we went, well, what's your margin? Is it 30% margin, 20% margin? No one even knew what the margin was. So we tried to get the discovery from them that would allow you to determine what the value of this entity was. Because we understood the law, and the law is what's set forth in Dillard's department store case. That was a case in the 80s. What happened is someone had an employment issue with Dillard's, so they sued Dillard's. And the issue that was teed up from the Nevada Supreme Court was, is Dillard's Nevada net worth the determinant of whether or not, or the amount of punitive damages, or is Dillard's nationwide's net worth the determinant of punitive damages? Can I have the holding that case, Chris? It's in the option, you know, page 4 or 5. So here's the bottom. There's the site, Your Honor, to, it's actually Dillard's versus Beckwith. Beckwith was named the woman. I think this was one of the first handbook cases. I don't know if you remember, there was involved for a while to use handbooks as contracts and then sue your employer. So this was one of the first handbook cases where they got human damages. So anyway, she was working for Dillard's in Nevada. I think she was actually over at the fashion show. Sued for wrongful termination, got punitive damages, and they challenged the trials court decision to allow nationwide worth rather than just net worth of Dillard's, Nevada. So here's the Supreme Court. We have previously allowed a nationwide worth when a jury decides punitive damages. Specifically, we have recognized the wealth of the defendant, relevant size of the board. Same principle applies to this case, Your Honor. It should be the total conglomerate's worth. I mean, what is Milwaukee worth? What is Hanna worth? And especially when you have all of these entities with no rationale indicating what they are worth. And so for that reason, we don't think there's any dispute as to what the standard is. It's not just, you know, the entity that sued. It's nationwide, or in this case, global net worth. That's the Dillard's rule, and that's what should be applied in this case. So Mr. Rich, again, he's an accountant. He's been qualified dozens of times. I don't want to go through all his credentials, but believe me, he has them, Your Honor. We can submit his resume if you want. And basically what he's going to say is, based on the materials he's been given, there's no credible argument on the part of Hanna that they can prove that they can't pay $500 million to or be annihilated. That's going to be his opinion. And, you know, they don't have an accounting witness.
We do. Mr. Elliott has been identified.
Oh, excuse me. Yeah.
What's the Nevada site for this, Rich?
Your Honor, it's a the Nevada site.
Yes.
You know, someone did put that in there. They should be saying.
Don't spank him.
Can you get that?
I'll get it.
I thought Dillard was overturned, by the way.
So 115 Nevada 372, Your Honor.
Thank you, sir.
Your Honor, I'd like to remind the court that we had this exact same issue in the propofol cases because Teva US came in here.
No, I don't remember.
Yeah, and the court ruled that we would use the worldwide net worth in that case. Not that your own decision is binding on you, but that was the decision at that time. Same argument being made. So for those reasons, Your Honor, we think this motion should be denied. I think the next motion is basically.
The first one was to get rid of Marcus Instruments, conglomerate. So I put them both together.
Okay. Yeah, the next motion is basically the same thing. You can't use a conglomerate or entities theory when evaluating the net worth of the defendant. They titled two different motions, but it's pretty much the same thing, Your Honor. And, you know, I don't know if the court wants to think about this one. I mean, this isn't relevant to the punitive phase, so you got the punitives.
Oh, no, I understand, but I just wanted to just take a quick look.
Okay.
Yeah. No, you can continue on, Mr.
I'm done, Your Honor.
Okay, thank you.
I think I get the last word on
You
this.
do, absolutely.
All right. Here's the issue. The plaintiffs got these organizational charts. They didn't do any of the discovery with regard to SID International. They sued one entity in this case. Then they sued SID International as an alter ego in all of the other cases under an alter ego theory. So in other words, and they've answered. They're in the other lawsuits. They're not here. There has to be what happened in this state of Nevada, specifically here, that all of those organizational, everything that they described, all these other entities did in this state. They didn't prove that. They didn't do the discovery for that. They have no evidence of that. They don't even know if any of the other entities besides Milwaukee actually sells a meter, which is why the court, you, in this case, at the beginning of these hearings, granted my motion in limine and got rid of the organizational charts related to this case, because all of those entities don't matter. It's really Hanna Instruments, Romania, SRL, dosing pump, who's the assembler, then it goes up to Hanna, then over to Milwaukee and sold, and that's it. Those are the entities. The parent company is SID. They're not even in the chain of distribution, okay? They just own SID International, SID International just owns them. I don't see where if an entity doesn't do anything in there, doesn't have anything to do with how this, in a punitive case, could be, oh, they're also liable. They're also liable. We gave the tax returns to the plaintiff for review. They reviewed them. I have the deposition testimony, 18 million, to now say, well, we think we're going to speculate. We don't know. We didn't do the discovery of what the value is of Hanna Instruments Taiwan. But if they're making money, we should be able to get that money too. They didn't do anything here. You got to have an action to be here for a punitive damages claim. What did Taiwan do in the United States? Remember, Chris, would you do me a favor and put the line up that you just had for Mr. Kemp, that part of his opposition? Is it okay? You just took it down. It's almost not that. I'm sorry, his motion. Yeah. I think that there's only a couple things I need to do. We're looking at this particular one, you're showing a particular site in the back of the case. All right. They cited the Dillard case. I think it needs to be shepherdized. But I'm going to look at line 17. In Beckwith, which is the Dillard's case, Dillard versus Beckwith. Plaintiff was an employee of Dillard's Nevada Inc. Now, know what it says here.
No, go ahead, I'm listening.
It says a subsidiary of Dillard's. Okay? Hanna Instruments Inc., the name defendant in this case, does not own Milwaukee. Hanna Instruments Inc., a Rhode Island corporation, does not own any other entities on this alleged conglomerate of Hanna.
Okay, no, go ahead, sir, I'm listening.
So the only thing I was saying, and I'll just repeat very quickly, Hanna Instruments Inc. does not own any other entities on that conglomerate. It doesn't own them. So how do I take their money for an action that allegedly Hanna Instruments Inc. did by selling, that's the only thing they did, sold the no RP meter to Milwaukee. That's what we did. And the punitive instruction with regard to that should follow. Doesn't make sense. So let's look at this. What the Dillard's court said right there. Beckwith, the plaintiff, was an employee of Dillard's Nevada Inc. Dillard's Nevada Inc. is a subsidiary of Dillard's. There's no subsidiary going on here. It's called SID International, and that's it. And they're not a party. They are a party in other cases.
But
They're not here.
in the Dillard's case, we had Dillard Nevada Inc., but it's my understanding their national organization wasn't a party, was it?
No, Your Honor.
So then you're saying it would be SID.
Well, the reason why I'm saying this is directly out of, and this is why, and it's interesting. I guess I had this one provision tabbed and might go all the way back to the opioid cases. I'm not sure, but I sometimes tap things. And this is what our Nevada Supreme Court said. Dillard objected to the trial court's decision to allow the nationwide worth rather than the worth of Dillard's Inc. to determine the amount of punitive damages to award. We have previously allowed nationwide worth when a jury decides punitive damages. Specifically, we have directly relevant to the size of an award, which is meant to deter the defendant from repeating his misconduct, as well as punish him for past behavior. And so, for the record, I mean, Nevada Supreme Court, as a matter of law, said, look, it's not just the entity that's a party to the case. So
tell me about all the international companies. Are they parties? And is it a limitation to the national ones?
well, National Dillard's wasn't a party, but they permitted.
But it says right there, you just read it, national only.
No, it doesn't say national only. It says we have previously allowed a nationwide worth
Nationwide.
when a jury decides punitive damages.
So do we look at an international worth now? Are we expanding that decision?
Well, I mean, here's the issue, is that you're saying, are we looking at international? I think what you're looking at is business relationships.
Okay, so we have a business relationship. We've discussed it. They're not parties here. Okay, and their money will never be there. I mean, they're international. I mean, we're now going to exercise jurisdiction punitively over entities that are not parties. We don't even know if they have anything to do with the instrument.
See, collectability is a different issue. Right? We can all agree, right? That's
Yes,
a different issue.
There's no question.
Yeah. I'm just saying, I don't know if you can, if there was a large judgment, I don't know if you can go to Romania and collect. I mean, I don't know. Maybe there's trade agreements.
There won't be. Yeah, it's not there. So it's fine.
No, but what you got to understand, what I'm trying to do is, what does Nevada law mandate, right? And one thing it doesn't mandate that the, say the national corporation or LLC or whatever it might be, because here's the issue, and I think this is implicitly recognized as far as this is concerned. You have so many layers of companies and LLCs and who does this and who does that. And I think implicit here is this: you look at it and say, okay, yes, you've incorporated Nevada Dillard's, a few stores, but at the end of the day, it's not just Dillard's of Nevada. They don't only have one store in Nevada and no other stores. They have stores nationwide.
Agreed.
And that's kind of how they looked at it. And I don't know if Dillard's Nevada Inc. was just a holding company. I don't even know what, I mean, they don't even go into the history. All they say is this: we have previously allowed nationwide worth when a jury decides punitive damages.
What's the nationwide worth? Because what Markers did not do is that research to determine that.
Okay, but he did give it. He gave a value, right?
No, he said we don't know, and we'll let the court decide. He just says, I could throw in $500,000 based on what? On a Romanian company. That was the evidence that he had. That's it. That's why I remember there was a motion early on in this that you decided that I said, the only thing I'd like to do is make sure that the Romanian krone, which is their monetary unit, to be as of the date that evidence is proper. So we looked at one Romanian company, and that's Hanna Instruments Inc. SRL Romania.
Right, and I think that's, when I look here, that's discussed on page 3 of the opposition.
The question I put the court is, do I report back to my client that all of the assets of Taiwan are now going to be in this case, because that's what the judges ruled on. That's what I need to know.
I mean, all I can do is go by.
That's fine.
Listen, no, you're walking away too quickly. This is what they have here. They said the comptroller of Hanna Instruments, who does work for SID's entities, the estimation of 100 or 400 million per year in revenue. And that was from the, is it Deprete deposition?
Huh?
Is it Deprete or Deprete? I mean, I don't know how to.
Deprete.
Deprete, okay. Depo at 3919, and business reports related to the Romanian entities and Hanna Instruments' inability to provide how much Hanna could borrow. And so it appears to me, and everyone can correct me if I'm wrong or not. I mean, I haven't looked at this entire report, but is that the basis for his evaluation right there?
Okay, so that's not half that's not 500 million. Those numbers aren't there. And so Mark Rich is going to come here and say, well, let's do, and then you have to do the annihilation analysis. We still haven't done that. So do you annihilate the whole thing at 400? Of course you do. So you can't do that.
Well, another issue was raised. I mean, I listened to lawyers. Mr. Kemp said, look, that wasn't alleged as a defense. I don't know if that's necessarily required or not. But anyway, the bottom line as far as annihilation is concerned, and typically what happens, and I've had a few punitive damages cases post-verdict, that would be one of the arguments that would be made if said, look, judge, they had this $100 million verdict, and that would annihilate my client. You have to reduce it.
Okay.
That's typically how that happens, right?
I don't disagree with you. I just want to make sure that I'm reporting back to you.
Am I missing anything, gentlemen, on that?
No, I'm just making sure that what I'm hearing is that the motions will be denied and that I need to report back to my client that Hanna Instruments, Inc., a Taiwan company, which is a part of this conglomeration now, that they're also need to be very careful with what they do because all of their money could be taken as far as the damage orders.
I don't know if that's true or not. I don't even.
So what's the ruling, I guess, is that's all I need.
I mean, I can't tell you what to report. That's what I'm trying to say. I mean, I don't know what the impact of it potentially could be because we look at that chart, right? And
which is not evidence now.
right. But I'm just saying, I don't know what the impact of that could be because is the Taiwanese entity, is that related or not? I mean,
It's not a manufacturer of the ORP meter. It doesn't sell from ORP meters through Hanna Instruments, Inc., a Rhode Island corporation. It's wholly separate Taiwan company. It just means that if you want a scientific instrument manufactured of anything, it doesn't have to be an ORP meter. They're selling all other sorts of scientific instruments.
Oh, I'm quite sure they do a lot.
Right.
But my point is, I'm looking here, the controller of Hanna Instruments, who also does work for the SID entities, estimation of 100 to 140 million a year in revenues.
Right.
And I would anticipate, and it goes further, it says business reports related to the Romanian entities and the Hanna Instruments inability to provide how much Hanna Instruments could borrow. Is that all from the Rich report?
I don't remember seeing that. He literally just says, we don't know, but I've got this report on the Romanian company. That's all I've got. And they look like it's a $40 million company in Chrome, which is they translated, I think, $240 million in US dollars.
Right.
I don't have anything on Taiwan. He never looked at it. In fact, I asked him that. Did you look at anyone else? No. Did you look at the SID entities? No.
Maybe it's good he didn't look at Taiwan because that could have increased the value. Right. I mean, I don't know. But,
so
I mean, the bottom line is this. I mean, I don't mind saying it. We can drill down a little bit. But if you take a look at the, I want to go back to the case law. And what Nevada Supreme Court said, you don't limit the value to Village, Nevada. You can look nationwide.
Nationwide.
Right? And we understand that, and this is a 1999, let me look at this. Yeah, this is a 1999 case, and here's my point. The way business has changed in the last 24 years has been fairly significant in this respect. They've gone international. You don't know where the products are coming from and those types of things. And I can't say as a matter of law, his estimation as far as value is off. We'll listen to his testimony. But we do have this, we have an estimation of 100 to 140 million in revenues per year. And I'll listen to his testimony as to whether or not that's an adequate foundation for his valuation opinion. But nonetheless, we'll have another issue to deal with, and that's the annihilation issue. Whether that has to be pled as an affirmative defense or not, I'm not 100% sure. I'm not ruling on that today, that we can handle that vis-a-vis trial briefs or something like that. I just want to make sure there's been no waiver. We'll attack that head on. I have no problem with that.
Okay.
And maybe it does, maybe it doesn't, but that hasn't been teed up for me. And so this is what I'm going to do as far as these two companion motions. I'll deny without prejudice. And at the end of the day, I'll listen to his testimony and understand where he gets his evaluation from.
Thank you, Your Honor.
Your Honor, I'd like to correct the record. I misspoke and said Mr. Rasmussen did not have an expert. He does have an expert on this issue, Mr. Eller. And so I just want to correct the record because I forgot Mr. Eller since I didn't do that.
What was Mr. Eller's opinion? Curious.
Well, Mr. Eller's opinion is that if you just look at Hanna US, their poor little defendant, they pay X amount. That's his opinion. He didn't have any, I don't want to go into it. But,
Okay, I understand. He just disagreed.
right. He disagreed.
Your Honor, I don't want to go into it either, but while we're previewing issues for trial, and I understand the court's ruling, I would just caution the court and remind everybody, I think, Dillard was 1999, State Farm versus Campbell was 4 years later in 2003. And that's the Supreme Court case that came down where the court said there is a substantive due process problem with punishing a defendant for out-of-state conduct. The state of Nevada has an interest only within its borders. So I'm not arguing the case. I'm not trying to get the court to reconsider, but there will be objections at trial based on State Farm v. Campbell, which I think affects the analysis the court just went through on Dillard's.
Judge, the problem with State Farm versus Campbell was that a bunch of the policyholders for State Farm were across the United States, and they referenced that during the trial.
That's right.
We do not have people that are victims in this case from around the United States that were thrown into the punitive damages. So State Farm, that portion of State Farm doesn't apply at all. The other portion of State Farm, the constitutional limit, which the court referenced being 9, I think State Farm actually says 4, and then it's modified by BMW versus Gore that says single digits. But since that case has come down, we've argued this to Your Honor before. Since that case came down, we have judges like Justice Posner in the Seventh Circuit who has said, it depends on the type of case, that when you're in the area of safety to the public, such as a food case, he had a bed bug case in front of him, such as a food case, the constitutional limits go a lot further in the punitive awards. And in that bed bug case, that's the Days In case from, again, Justice Posner of the Second Circuit. He approved a 99-to-1 punitive ratio. I'm not asking the court to make a ruling on that issue now. I'm just saying that there's a big difference between single digit and the 99-to-1, and that's all post-trial. Okay, nobody gets into that post-trial, pre-trial, but that's why we can ask for as much as we want. Whatever the jury gives us, we got to live with. But then the analysis is done when they file the motions based on State Farm and the BMW versus.
And I just wanted everyone to understand this. I do agree in this regard that that's post-trial, but I'm trying to remember what the figure was. But I mean, I had a $500 million punitive damage verdict, and I reduced it by how much? 450 million?
Yeah, you
something
cut a
like
little bit,
that.
Your Honor, but I think we had.
I can't remember what it was. It's been a long
I think
time.
you're
But-
all
familiar.
Yeah,
your
but
case
I
confused with Justice.
I don't know which one it is, but I know I reduced it significantly.
Judge Walsh, I think we wanted 18-to-1. That's what we wanted there. I can't remember exactly what.
I think it
She
was.
did reduce it.
I think it was more 10-to-1.
Yeah.
I mean, because what I did was I followed. What's the State Farm case in Utah?
Campbell, Your Honor.
Camp, wasn't that the 10-to-1 limits?
Yes, sir. I believe it was.
I thought that was 4, and then BMW versus Gore was single.
I don't know, but I would dare say, and I could be wrong, but I know I'm almost positive I followed the Utah case State Farm, and their outer limits were 10-1.
That's my recollection as well, Your Honor, but it's not.
Yeah.
One's
We all
single
understand.
digits, one's 4, okay?
Right.
Yeah.
And so all I'm saying is this, I do understand that you can't annihilate. I do understand the limitations. I do understand whatever the punitive damage award is in a case to stand at the end of the day. After I make a decision, it has to be tethered to the compensatory damage. I get that.
Yes, sir. And I think there's some requirement that it also be tethered to in-state conduct.
And you know what we can
We'll
do?
leave that for another.
And for the record,
You
that's,
can't punish for out-of-state conduct.
Yeah.
That's what the case says.
yeah.
It doesn't have anything to do with the amount of punitive.
And here's my point. I'll be real clear on this. I will listen and entertain all arguments on that issue. Nothing's been waived. And obviously you have a record as to exactly what I did. And I don't think was it 10-1? Go ahead, no, you can tell me. You know.
Or in your opioid case, or your endoscope case.
Yes.
Uh,
It was 10-1, I think. I'm almost positive.
I can dig it up.
It should have been, Your Honor, given the date, yes.
Yeah,
I would be
it was-
surprised if it was more than that.
Yeah, it was 10-1. Yeah, that's what I did because I think the verdict was like 50-1 or something
Right,
like
the
that.
case says single digit, it doesn't say 2.
That's right. We agree.
Yeah, because
9.9 million is single digits.
and my point is this. I do remember there's two things I did in that case. I don't mind telling everybody what my thoughts are. I'll tell you this. There's two things I did in that case. Number one, of course, I read the State Farm case. I think it was State Farm. But also, I remember reading some analysis from Justice Mahan from the Supreme Court. I mean, from the Federal District Court. And some of it was quite compelling to me. And I looked at that too. But just for the record, all I can say is this. If hypothetically there was a controlling case and said, okay, the new law is 3-1, I would do what they tell me to do.
So would like to, before we break for lunch in 9 minutes, I think I can resolve 2 more. Because I think,
What I heard was we'll put off that until later. I don't think Scott's arguing that. It's the same issue.
3 and 4,
Let's talk.
we'll talk.
All right. We're going to lunch?
No, I was going to try to get 2 taken care of by saying the following.
Which one we do?
Was going to look at number 6, which I think we previously kind of looked at in the companion motion filed by the plaintiffs. So this is Hanna Instruments motion eliminating number 6 to exclude testimony that the MW500 ORP meter adds chemicals to, in this case, water. Okay. Mr. Kemp and I think he had a motion that was similar, saying that I can't use as a defense that my meter doesn't add chemicals to water. But I get to, according to the court's ruling, tell the jury that my meter does not add chemicals to the water, which is true. And so I think this issue's already been decided by the court.
Now, when you say add chemicals, does the meter change the chemical composition of the water?
It's a measurement. It's like a tape measure. Well, this is the height of this particular piece of wood that I'm going to add in there, and that's all it tells you. Does it tell you, like a thermometer, does it tell you
Which motion is this for, Rick?
number 6? It only measures. It doesn't add anything. It doesn't take away anything. It doesn't test anything.
All right.
Oh, wait.
Okay.
I'll wait. Number 6. It's a pretty straightforward motion. That's why I was hoping to get
Exclude
this done.
testimony that MW500 adds and/or it says reads chemicals.
It can't even read chemicals. So the other part of that is that, remember, Your Honor, and I put this in several times, all that the meter does is tell you the electrical current of the solution. It doesn't tell you, oh, this has hydrazine in it. Oh, this has magnesium in it. This has potassium in it. This has a chloride in it. It can't tell you what chemicals are. It doesn't do that. It tells you in millivolts what's the positive or negative charge of the water. Negative charged waters are called alkaline waters. It only tells you a number. Just make sure you. Let's see. I think I have boxes in that way down there. There's one box and there's a meter there. Man,
Interesting. I mean, this kind of sums it up on the opposition. This is on the second page. It says, quote, defendant Hanna Instruments' motion and overall position on the issue is why I don't know if I necessarily, but I'm talking about motions and limine regarding reptile.
it's a pretty hard place to go to. How do we address that to the court when those sort of tactics are used? And I think we just have to deal with it when it's in the trial. We try to just.
Well, actually, I look at it differently. I mean, I think at the end of the day, you can't hamstring clever lawyers making arguments, right? And, you know, I understand we have reptile theory, but lawyers have become very sophisticated, and I wouldn't be surprised at all that in this specific case, there's consultants out there that assist in helping lawyers.
Mr. Gallagher was doing reptile theory before the book came out.
Yes, it was. Yes, he was. Yes,
All right.
he was.
So motion.
You know what? I don't mind saying it. That's why I remember doing some of the appellate work for him as it pertained to voir dire. And I can't remember which case it was. It was in front of maybe Judge White. There was a artificial 15-minute limitation on voir dire. And I remember him explaining to me how unfair that is and the importance of voir dire. And that's actually impacted how I view voir dire. And I look at it from this perspective. I'll tell everyone this. You have a full and fair opportunity to take advantage. Some lawyers do, some don't. And that's on you. But I let lawyers do what they have to do. And just as important too, and this is very important to point out, if you take a look at the rule of professional responsibility, I think I've cited it before, it said you can investigate any basis for challenge. I let lawyers do what they have to do. I don't know who's guiding you, but you know, that's okay.
Okay.
So getting back to your real quick one again.
No, so I got the denial on the reptile. We understand it. First things, because we're going to go to lunch, I suspect.
Right.
Is as far as I can tell right now, I have motion eliminating number 5, motion eliminating number 8, 9, 10, and 11. That's 5 to go.
Okay.
Plus dispositive motions. And after the break, I would like to start with my motion with regard to spoliation. And I believe Mr. Kemp asked me to go ahead and wait on that one until Mr. Peppermint is here, and Mr. Peppermint is here now. So is it okay that we begin that after lunch? All right.
Where are we going to go after that?
Are you able to handle 8 with that? Because they're both essentially the same.
Well, they're not exactly the same, but we can handle both, yes. So that's why I wanted to make sure that you knew where things are at, and we'll go through that. And I anticipate that will take a while on spoliation, okay?
All right.
Are we denying the reptile theory one, or are we?
Yes, he denied it.
That's the easiest one so far.
Yeah, I'm not a reptile kind of guy, so.
Yeah. I kind of think reptile's been a little bit overplayed. I think I think where lawyers have really, this is where lawyers have really changed since I practice, and it's the focus groups. That's where, you know, and how do you present your case, and
Yeah. I think Mr. Friedman was just selling books, Your Honor.
yes.
All right, with that in mind, Your Honor, that's all I have.
Yes, I understand.
I've told the court, I think where I'm going to be heading to next. So
Next up will be motion and limiting
No.
number 8.
There will be a motion for summary judgment, which is not really a summary judgment, it's a motion with regard to spoliation of evidence.
I understand.
So that's not summary judgment, because spoliation has nothing to do with summary judgment. It has to do with conduct of the plaintiffs.
Well, actually,
Counsel.
it's slightly different. It has to deal with evidence. And
Yes.
whether the evidence has been lost.
Yeah.
It can't be obtained. And
We'll go
whether or not the missing evidence is relevant, right?
Okay.
And then the court can look at it from many different respects.
Lay all those out for
And
you.
we can do inferences, presumptions, all those things. I get it. But at the end of the day, you listen to it. And we have Bass versus Davis, and we have all the other Supreme Court cases that deal specifically with spoliation. I got it. So let's go to lunch.
How much like it's back around?
1:15, and we're actually making some headway. I would dare say that, and I know with the stipulation, I think that has to change the whole posture of the case from a significant manner. I don't know if it gets a couple weeks off, but I would think it would.
Just trying to help.
Yeah.
Move it along.
Yes.
Thank you, Honor.
And last but not least, can you gentlemen advise me of this? If that's the way we're going, right? What impact does that have on anything I have under consideration?
Yeah, that's what we're doing these two when we come back.
Your Honor, I think from, I'll let Mr. Kemp finish. what he's
Don't
doing.
know right
No,
now.
go ahead.
I'll let you know.
Let the judge go. Sorry.
Oh, that's okay. I just wondering because, for example, anything I might have under consideration with the
Your Honor,
stipulation.
We think it does, and to the extent that some of these other similar complaints are not really relevant as to real water. They may be relevant as to other defendants. I doubt Mr. Kemp may agree with me on that, but we do think that the prejudicial nature now outweighs any probative value because the only issue for the jury, as far as real water goes, is reasonable damages.
Judge, I think they're relevant to the punitive claim, so I do disagree.
So I will tell you that what happened, because Mr. Kemp just
It's haven't
asked me.
stipulated, so what do you?
No. Mr. Kemp asked me what I'll be doing after that one. There's another motion to have here on something with regard to joint and several liability, and that'll be the one I go after that. Am I jointly liable with UNFW and Real Water for the water product? When I have the ORP meter, that's what we'll be discussing after spoliation.
After that, there we go.
I don't know right now, Will.
Just let me know if
But I'm just trying to get a heads up of the ones that we've got right
there's
there.
not many left. Okay.
I know that. There's only like 4 or 5 after that. And some of it will be very short, so, but those, I assume the court wants to be done today, but if maybe we have to be back, we'll be back on Tuesday.
It is what it is, but we have an extra half day.
Sure.
As a judge, I can't complain because you've made significant movement and agreements on certain issues. And that benefits the jury at the end of the day. And that's kind of how I look at it. And also, I understand this too. You can't rush justice. It is what it is, right? And you have to have an opportunity to make the record. And as a trial judge, I rule. And if I rule your way, fine. If I don't, and you disagree with it, everyone has their appellate rights. I respect that too. All right. Maybe we can enjoy the weekend a little bit.
No, Your Honor.
We will be doing other things. Thank you, Your Honor. We'll be back at 1:15.
Okay.
All right.
All right, let's go ahead and set forth our appearances.
Will Kemp and Eric Pepperman, and I'm advised that Mr. Parker will be landing shortly, and if you could conclusions probably in half an hour or so.
Okay.
Good afternoon, Your Honor. Joel Odou on behalf of the real water entities.
Jim Neale, Your Honor, with David Spurlock on behalf of UNFW.
Scott Rasmussen on behalf of Hanna Instruments, Inc.
Good afternoon, Your Honor. Rob Robbins from Milwaukee.
All right. I think that's it, right? Okay. Where do we go next?
Right here.
Foliation, right?
Yes, Your Honor.
Okay.
All right. This is our motion to eliminate Hanna Instruments' motion to strike plaintiff's complaint for despoliation of evidence. We do recognize that inside of the complaint that there are other avenues that a court may take based on the case law in Nevada. But in order to do this, and putting out there everything that's going on, that some of the facts of what's happened in this case need to be known by the court in order for it to be able to do proper ruling. First, start out, please, Mark, if you can pull up the special master order, number 1. So going up here, we have had, let's go for the top, make sure I'm good at the, we'll see one there, maybe at the end of this document. Very end of the document. We can start there. December 14, 2022, Special Magistrate White held a hearing. This was well after the first time that the court, I think it was Judge Gonzalez actually, that did the initial order setting up a, I think it was a pause for documents. They also set up the vault for the different physical evidence, and then they split up the rent with regard to the Henderson facility. On page 1 of this order from Special Master Floyd Hale, it talks about the Henderson facility rent. The very first line of that, line 27, says, the Kemp Jones law firm has paid the rent for the real water facilities to, and this is the purpose, preserve evidence. So what the Kemp Jones law firm was first asked to do is preserve the evidence at the real water facility. They took on that responsibility. It was their job to maintain all of the evidence that was there or any of the evidence that they took from there. Okay? Let's look now at some of the evidence that we dealt with, and you've seen some of these photos already. Looking at Exhibit A to our motion, Your Honor, are some photographs of the probes and the meters that we looked at as a part of the discovery process in this case, in which we looked at all of these different things that were found at the evidence vault during discovery. You can go to number 6 and 7 first, Mark. So first we found the meters. We found the oxidation kit. You note that one's clear and one's brown. That's by design for those particular things. Moving on to number 10. Found the meters. We found this as well, which we thought was interesting because it may even argued that somehow we were involved in, our company did the pH. pH is done, but the company that they used in order to do pH was a company called General Hydroponics. It is not product of Hanna Instruments. Okay, go to the next one. Be number 26, I think. We then saw these. These are the probes that were found at the Henderson facility. Okay, these probes and meters migrated from the Desert Inn facility to this facility. Okay, we know from the deposition testimony of Casey Aiken that he did not do the oxidation of the probes, but that was done by someone else. We do know that Blaine Jones testified he did oxidize the probes, and then you saw the videotape in which he actually does that. So let's go through a series of these particular ones. Let's go to number 29, or I'll just keep going through these, I think. 26, one of the probes, another picture of the probes. The important part when I look at this particular photograph, Your Honor, is that there's a couple of different parts to this, and the very top, the far left, is the cap that goes around the probe's tip. Okay?
Do we know if the probe works or not?
Well, it was working when it was at the facility in
But my question
October, November, December, January of 2020 and 2021.
Yeah, but I mean, the probe is at the, I would anticipate the evidence depository of some sort. And has there ever been a request to go out and run tests on the probes at issue?
Yeah, but I'll get to that because here's what we found. So we looked at this probe, and then we had our chemist view these photographs that we took when we did our inspection. Okay, go on to the next one. So that we can get to the...
You did inspect the probe?
We did.
Okay.
This is our photographs from our inspection. You'll look at this one, you'll see there's no fluid around the probe. Okay, there's no solution. Okay? Keep going. Same thing. We're just showing you that it's gone. It's been dried up. Same thing. All dried up and gone. Keep going. Keep going.
Were they tested?
Well, yes, we will get to that right now then, because,
Because I've seen the pictures.
okay, you've seen the photos. Let's go to Exhibit B. So we took the photos and we sent them to our chemist, Dr. Babcock, and said, here's what we're seeing, okay? Now, I'm going to analogize this to like a doctor. The doctor looks at an X-ray. He has a different opinion of what he sees on an X-ray than when I look at that X-ray. When I look at the X-ray, I say it looks like some bones maybe. When he looks at them, he can see all sorts of things, okay? Because he's a doctor and he's been trained with this. We took the photos, we sent them to somebody who's a chemist. He says this in his declaration, Exhibit B. I have a PhD in chemistry in 1980 from the University of Chicago. Personal knowledge of the facts set forth herein. 4, I have inspected the photographs of the ORP meters and probes attached here too as Exhibit A. Photos that you just looked at, Your Honor. Number 5, he says the probes are dried out, thus rendering them incapable of being properly tested. So in his opinion, and we do have it in number 7, I believe to a reasonable degree of scientific certainty that the ORP meters and probes attached here too as Exhibit A are in such a condition that renders them incapable of being properly tested for functionality. Period. I declare a penalty of perjury under the laws of the state of Nevada that the foregoing is true and correct. So he's put his declaration under those things, under the penalties of perjury that I've looked at these photos, I'm a chemist, I know what ORP meters are, he has experience with ORP meters, he knows where the caps are supposed to be, he knows they're supposed to remain moist, gets us to the instructions on this. Can we go to that section? Now, I need to go over a couple different spots. Let's go to recommendation first, I believe. No, it's going to be the maintenance section. Right there. Thank you. Pull that up for the board, please. Maintenance. The surface of the ORP electrode, that's the very platinum tip. Let's always be clean. Use this particular kind of rinse solution for this purpose. If needed, any platinum tip with very fine abrasive paper. Next one. When not in use, the tip, meaning this platinum tip of the electrode, should always be kept moist and safe from any mechanical stress. Okay? So the instruction in the maintenance section that has been in the possession of the plaintiffs, and for which they're critical that these are inadequate instructions and there's not adequate warnings, and this is not adequate, is that the tip of the electrode should always be kept moist. Thus we have that cap on there to keep a solution in there so that they remain moist. Okay? What we found in June of this year when we looked at them during discovery, and I admit it was at the end of discovery, but let me make a point for you, Your Honor. My company has been or is involved in well over 20 of the lawsuits. These meters are the only meters that is the evidence of what was going on in the Henderson plant and before that the Desert Inn plant for all of the cases. I will likely have to file this motion with regard to spoliation and all of the other departments because, as Dr. Babcock just testified, I've looked at the photographs as a chemist. I think they're all dried out, and therefore I render that they are unable to be used. Therefore, because why? They were not kept moist. Let's go to the second part of the recommendation. Recommendation. Before using this product, make sure it's entirely suitable for your specific application. and for the environment in which it is used. In this case, it was being stored, and I think we have some photos, Mark, of the place, the actual storage facility. Can you get those for the judge? So this is where it was kept in Las Vegas, in a box. The plaintiff suggested that this was somehow was climate controlled. Now, I don't see any roof-mounted AC units. I've lived in Las Vegas like you have for a while. I don't see any air conditioning. This is not a place that's climate controlled. My associate attorney went down to this location to look at these and took those photos that we provided to the court. I asked him, is this climate controlled? He said no. So when they're kept in this place, they're not under climate controlled condition. Okay? Let's go to the warning label on the side of the box of the Milwaukee machine, Milwaukee instrument. It says warning. The enclosed product is intended for use by persons knowledgeable in safe laboratory practices. So there's our instruction. And this warning somehow is inadequate. It doesn't tell you what to do. But let's see what it does tell you to do. If you're going to have this product, this instrument, people with knowledge should be the ones that are dealing with it. Well, that puts the burden, since you've now taken control, plaintiffs, of this instrument to make sure it remains in safe laboratory practices. In other words, how are you going to maintain it? That's your burden. You've taken control of these. You could have said, Mr. Rasmussen, you're now the case, we'd like you to take control of these. That could have been an option for them. They didn't exercise that. And that's okay. We thought that they had them in a place that would work. Then it says, next sentence, failure can result from surface damage, improper pressure or temperature, or used with improper chemicals. Now the focus on this one is temperature. These were not kept in a place where the temperatures were good for 2 years. Okay? Now they were either at the Henderson facility with no air conditioning, or they were at this storage facility where there was no air conditioning, low humidity, all the stuff that we experienced in Las Vegas over the last 2 years. And we know this from living here, that this negatively affected the ORP meters to the degree that our chemist said, hey, you can't test these. And one of the things you keep asking me to say, well, who tested the meters? Well, we couldn't. During discovery, we found that all of the meters were dry. And as a result of not being dry, they, according to the instructions, they must remain moist in order to be able to test. You can't.
Why can't you moisten the I mean, at the end of the day, and I look at this, I don't know how big of an issue this is in this case, but he looked at photographs, okay, they had something on them. But when it comes to instruments, all sorts of things, how do you know it didn't work?
Right, because he, as a chemist, said all of the water in there is gone, and just by that fact alone, I can tell you they don't work. Now, that's a chemist saying that. Otherwise, this is what the same arguments that I get from Mr. Kemp. I'm not a chemist, but I can tell you, you should have gone out and tested them, or you should have re-wetted them. They're going to tell you that Carl Salvaggio, not a chemist, but the operations manager at Hanna says you just have to re-wet them. False. You can re-wet them.
But Hanna's
a day.
But I mean, Hanna's the manufacturer, right? Or they produce this stuff. They don't know.
But go ahead and tell me what your question is.
But what is Hanna? What's Hanna's relationship? Isn't this part of their product?
No, well, they remember they just sell them. But be that as it may, do we know about them? Yes.
And they sell them.
Yes, they do.
Right.
Okay. There's more to it. I think I've gotten that box over there. There's a white cylinder, just so the judge can see what I'm talking about, because there's more to it.
I get it. I mean, everything you've said up until now, I understand. They were stored. It wasn't in a controlled environment. It was in Las Vegas for 2 years. I understand that.
Okay.
But a lot of electronic devices are stored in storage units in the summer in Las Vegas, and they still can function after that time period. So my question is this, and it's real simple. I understand they didn't have a fluid in there, but it's a meter, and the meter itself wasn't tested. The photographs were obtained from a chemist, and I understand chemists do wonderful things, but they don't manufacture the meters. And you're telling me because it didn't have the chemical in there and it was stored at a high temperature for 2 years, it doesn't work, and he's viewing it based upon photographs. Mm-hmm. My question is this: why couldn't he just gone out and said, look, we want to test it and see if it works?
So there's, I guess, an opinion by Dr. Babcock that testing it would be futile because there's no water left in the probe.
Can he put water back in the probe?
Okay, so let me show this to you. All right, show this to the judge.
Sure.
Because it measures current, right?
Your Honor, you're going to see that there's two different spots. The bottom spot is the spot that is completely dry. In other words, inside of that plastic casing, the white casing at the bottom.
Right, I understand.
And we saw that on the photographs, right?
No, I understand.
Okay, the top part of it is also filled with a gel. It's not water. In fact, all of the stuff that you're seeing there is a chemical. Okay? Chemical below is what you can store it in until you move to it. We already showed you this other stuff that becomes vinegar. This stuff up here, you can't replace. Once that dries out, it's gone for good. Okay? Now, I'm not a doctor, but I know when a doctor looks at the x-ray, he can say, I can say, well, why don't we just do this? And the doctor says, no, it doesn't work that way, Mr. Rasmussen. This is what it shows me on the x-ray. Our chemist looked at this on the photographs and said, no, it doesn't work this way. So then we thought, well, then what will happen is they'll get a chemist that will come back and tell us, oh, this is what you should do. Or, no, we should go test it anyways. But Dr. Babcock put his reputation on the line and said, it is futile to test them. Go back to his statement again. Number 7. I believe to a reasonable degree of scientific certainty that the ORP meters and probes attached thereto as Exhibit A are in such a condition that renders them incapable. Okay? So if the court wants me to go out there and test meters that are incapable of rendering anything, I guess we can do that because I'm going to open it up, I guess, for discovery in all the other cases. And I'll go ahead and do that. We'll get them all to show, nope, it can't work, and then I'll just file this motion in the other ones. But to avoid that, we just says, look, here's the declaration. He's looked at it and says, it's dead in the water now. Carl Salvaggio, the operations manager, says, if it dries, it dies. In fact, it's in one of the chat discussions that we're going to have in another motion, so why anything after dates of when these people got sick should not come into evidence in this case, mainly for lack of foundation. But that's his testimony. Once they dry, all of this dries, it dies. It's done. If it's within a day or two, you're fine. This isn't a day or two, Your Honor. These are months and years that they've had these. Okay? Now, the question then becomes, is this negligent or is it willful? Well, the plaintiffs in this case have been telling my folks from the beginning that your instructions with regard to these meters and these probes have been inadequate. They're not. And then therefore it's rendered that meter right there to be dangerous. And yet, if that's true, they obviously weren't reading the very paragraphs I just showed you that said, keep them moist. They didn't do that. It's not my fault that they didn't keep them moist. All you're saying is, well, why didn't you test them? Because my chemist said they're rendered incapable. You can't do it. It is of no value. Should I just do it anyways and not follow the advice of my expert who says this is the way it should be done? Is that how? Because what should happen then is I should get a chemist from the other side to say, no, you can test these. That's not how this works. Instead, we have
again, someone on the other side saying, I know we don't have a chemist over here, but I'm going to tell the judge, you can go do these things. And if you can go do these things, then you should just go do them. But I've got a chemist telling you it renders it incapable. All right. Let's go to the rest of the motion so you see this. The judge, as you do, the court, has many different things that it can do with regard to these sort of motions. As you know, and you understand the law, and you've already explained that. You know the law on this. You can do negative inferences. You can do all those sorts of things. But if the court is just going to say, no, you needed to go test these, even though the chemist said don't, or it's of no value, and I guess I can stop with this motion. You can just tell me, nope, I'm going to deny the motion because you should go test it. We'll go test it in one of the other cases. It's still open for discovery. If that's what you want me to say, that's fine. Brianna Switzler did reach out to the manager of the Mini Masters and says that this is climate controlled. I'm going to take her at her word on that, but the reality is that we did not find that to be true when we were out there. In any event, we found that all of them were, in fact, meaning the probes were dry. The photographs show that, and a chemist looked at those photographs and found them to be dry. I've been to the Henderson facility. I did not find that that was an air-conditioned place where they had these out there. The question then becomes one of willful. If you know that there are instructions in the manual for how to do this meter that says keep them moist, and you're criticizing my client, saying that
Not criticizing.
no, not you. The plaintiffs are criticizing, Your Honor. I apologize. I probably said you, and I shouldn't have. I would have said the court. If the plaintiffs are criticizing and saying it should have been different instructions, but you don't use the instructions that are there, meaning you, the plaintiffs, in how you maintain the probes, and you don't maintain them, then you're willfully creating the problem. I mean, you should have kept them moist. How easy is that to do? Let me explain. Day 2, you get them, okay? I've got this probe that needs to remain moist. What should I do? In the instructions, remember, we did the oxidation. We showed it yesterday, the 2 bottles. Now, you remember these instructions right here? Very bottom says store conditioned probe into the conditioned probe in white distilled vinegar. Casey Aiken was asked during his testimony, his deposition, did you in fact store the conditioned probes in white distilled vinegar in between uses? Answer, yes. That's what we stored them in. Said that in volume 2. So he did that. Then the lawsuit starts, and what do we get? Well, these are now transferred to the plaintiffs for maintenance and to preserve them. These were not preserved because all I would have taken is take off that cap on the front, the very bottom of the electrode, at the bottom of the electrode, and add some more distilled vinegar. That's all they would have had to have done. From time to time, just go make sure there's distilled vinegar in there. Once you do that, then they're okay. They are maintained. But to not do anything is when you have the instructions here that they've had, you render them incapable of being able to be tested. I think that's something that we needed to have to be able to test them. And if my expert says, hey, they are rendered incapable, then that's where it sits.
What did Mr. Babcock do? Dr. Babcock. Who's Dr. Babcock?
He's a chemist, PhD chemist, right at the top of his
and,
B.
and that's your expert?
Yes, sir.
Okay.
Yes, Your Honor, I apologize.
Yeah, I'm just trying to make sure.
Dr. Babcock is my expert, PhD chemist. It's his declaration that you found as Exhibit B that I just cited from. He says that they're rendered incapable of being tested. I don't have much more to go with because I know that the court can do many things here.
And so here's my question, because at the end of the day, the thrust and focus deals specifically with the adequacy of warnings, right? As far as product inserts and those types of things. What does this have to do with warnings?
So if you test them, right, and they came back having been in a conditioned, they were conditioned, and they were in vinegar, and they were still preserved, we could have tested them and found they were accurate. Thus, whatever warnings and instructions were there, they're still accurate today. Here's evidence.
Are we contesting accuracy of the
Yes.
probes at the time they were being utilized?
Yes.
I mean,
Yes.
so is there an allegation as to, I just want to make sure I understand, that there was some sort of manufacturing and/or design defect vis-a-vis the ability for the probes to determine the specific findings as far as positive and negative orb?
Yes, there is an allegation that the accuracy is in question because of the way in which you needed to be conditioned. So in fact, if
No, that's
Sorry,
different.
but I
They
didn't-
need
I
to be
misunderstood
conditioned.
your question.
I'm talking about as far as, did they function? Is there any, I understand conditioning, I understand that, but I'm talking about as far as, is there an allegation that the meter was defective because at the time it was being utilized at the plant, it wasn't functioning correctly based upon a mechanical design or any of those types of defects?
yes, with regard to the instructions on how to.
That's a different issue.
I'm so sorry, Your Honor. I apologize. I'm not trying to be in any way flippant here. They are saying that it is defective because the way you condition it was never done well by our instructions. And I understand you don't want to hear that.
No, I want to hear it, but I mean, but here's the point.
There is no defect for manufacturing
Or design.
or design.
Okay.
We had that yesterday. You asked Mr. Kemp that. What they're claiming.
I mean, I
is-
know that, but I'm just trying to make the record.
What they're claiming is that when you're oxidizing these, which is what we have here, these are the instructions that are up on here, that those were not clear, and thus they gave, once you went through these instructions, somehow the probe was not accurate because it was never conditioned properly. Okay? So what we know and can test for is, was the probe and that platinum tip, was it ever conditioned? We can find that out. We looked at it. We can't because they've been rendered incapable of testing because they were not maintained. Now, I don't know if I hit the right question or not for you. I don't like to frustrate the court. It's not.
Okay, no, I don't get frustrated. I don't. I really don't. I'm just trying to make sure that I understand the issues.
Okay.
And so when was the request made to inspect? At what point? In the
June of
litigation.
this year.
Okay.
I want to say probably around June 1st when we made a phone call. Hey, when we can do this, the date was set. We actually showed up at the plaintiff's law firm. We thought that's where they were being held. Turns out, no, they were down at that mini storage facility. So we went down there. My associate went in, they took photographs of them. We sent those to Dr. Babcock. Dr. Babcock then rendered his opinion, which you have in Exhibit B. The return to that is, no, defendant, you have the obligation, this is what, in their opposition, you had the obligation to tell us how to maintain these. Well, the maintenance of them is right there in the instructions, right on the screen. So you take in a new probe, this is how you condition it, and then you always store it in distilled vinegar. And then we showed you the instruction that said, always keep it moist. That's the clinch right there. They have to keep it moist. They didn't do that, thus rendered it incapable of being tested. Now, if they had their own expert, not just them speculating on these things, as a non-expert, hey, we think they're fine to be tested and you should have done it anyways. Well, I listened to my expert, he says, no, it doesn't matter. They're gone. They're dry. They're over. They're dead. You can't. It's like,
Testing something that doesn't exist. Do walruses fly? No, not under any suggestion that I can have. So, if you think we haven't met the burden of spoliation, that these things weren't maintained properly and couldn't be tested, we wanted to test them to see if they've been oxidized and whether or not they read accurately. Because Mr. Kemp believes that the reading of these things tells us a lot about the accuracy of those. We believe oxidation only affects the speed, but we could have tested for the speed of how fast it stabilized. If we had...
No, go ahead, because I'm going to listen. I'm listening, because I was just thinking about my prior ruling as far as this is concerned. And one of the issues I think I ruled as far as the more recent meters, and I don't think my decision hindered on this, because I said they could all be calibrated. Right? Didn't I say something to that effect?
I hope not, because calibration, they're factory calibrated. Can we go to...
No.
You walked into it.
Pardon?
You walked
You
into
walked
it.
into it.
No,
Calibration.
but no. What? Please understand this. I'm going actually in a different direction. And what I meant by that is this. Didn't I make a ruling regarding, didn't you file a motion to eliminate?
Yes, Your Honor, we moved to exclude Dr. Babcock's testing because he tested different meters on a different test
Exactly.
solution. And you said,
The testing solution was a duplicate.
I'm excluding the testing because the testing solution was different, but I'm not ruling that the meters or the different meters are important because
They could be
they could
calibrated.
be oxidized. Or
Oxidized. Yeah, that's wrong. I'm not walking into it, right?
Condition.
Conditioned. There you go. I just want to make sure I don't use the wrong term.
That's right.
But I knew I said something like that, which made
we have
perfect
that.
sense.
So can we test the actual meters, which would tell me if they were conditioned and therefore read accurately? The answer by Dr. Babcock is no, you can't. They're rendered incapable of being tested.
Now, when he bought the 5 or 6 or whatever meters,
When we sent it 14,
the 14
we
meters,
use it.
right?
Yeah, 15
At that
total.
time, why didn't you request the actual meter at the depository to send to Dr. Babcock to see if they could be used or not?
Okay, so we didn't because we wanted to see whether or not we could do something different first and see what that came up with. You didn't like the testing because it was just not duplicative of the testing solution. That's what you found, but we thought we were fine with that because it was substantially similar testing solution. The only difference was we didn't have that Russian probe, a Russian tube.
Well, I think that's kind of a big deal.
I think you do.
Yeah.
We've got your read on that.
Yeah, but I'm getting back to it. Prior to Dr. Babcock performing his testing function, and he did what, 2 tests? 2 series of testing or just 1?
He did like 6 or 7 series of testing.
Okay, getting back to that.
Okay.
Why, if that was so important to test
That was
No, I'm just being real
No,
simple.
I'm trying to hear.
If it was so important to have the actual meters in place that were utilized at the plant at the time this unfortunate event happened, why didn't he ask for those so he could run the testing with the actual meters?
We wanted to first test to see whether or not how long it just took for the conditioning stabilization process to exist. Right out of the box with no oxidation conditioning done. So in other words, assume for a second we have no oxidation done. Okay, none. Okay, so we're going to be conditioning, we're just talking about right now. If you don't have any conditioning done out of the box, can an ORP meter even tell if it's an alkaline water? Because Mr. Kemp at the time was making statements that you can't even see if they won't even tell you if they're alkaline if you don't condition them at all. And Dr. Babcock's testing was really about that, and that's what I told the court. It's about whether or not it can read alkaline at all. Now, we had an alkaline test solution because it read negative. It read negative 148. I showed you that. That was what we talked
Well,
about.
no, the difference there was it was a question of timing, and your testing would give the jury that could misrepresent to the jury that this is done just like that. Because I remember reading some of the deposition testimony or whatever,
Right.
and I know that, and forgive me for not knowing the exact term, but as the negative ORP readings rose, there's a question as to the process slowing down and not reading as quickly And I got that. I mean, I
Right.
pulled that away.
Right.
And so, what Dr. Babcock and his testing, oh, it's done just like that, well, maybe not. And this is important. We didn't have the solution. I know where I was going on this. We didn't have the solution. And so we don't know for sure how long it would take to get to that reading in the 225 to 300 range or whatever it was.
The
Something like
solution
that.
that we had was never at negative 225 to 300.
That's the problem.
Right.
That's the
That was
problem.
the problem that the court found.
Yes, that's the
The
problem.
question that you also, because your ruling was so broad, is we can't even put in front of the jury how long it took to do negative 148.
But that's not relevant. As far as this is how I looked at that, because as you go up the scale as far as negativity, maybe that's the best way I can say it, or readings,
Okay.
it takes longer for the reading to occur.
And the answer to your question on that is Dr. Babcock, the chemist, would tell you that's incorrect.
Well, anyway, I understand.
So our expert looked at that and said, how long does it take? Now, when you condition.
Well, we would know for sure if we had the same solution. That's my point.
So
Right.
I don't want to re-argue that motion.
No, but I'm just saying, I mean, this is a good discussion, but that's what I focused on. But go ahead.
So if it was negative 750, it would take 2 minutes. If it was negative 500, it would take 2 minutes. If it's negative 300, it would take 2 minutes. If it's negative 225, it takes 2 minutes. The amount of time between those things might be a second more to get to that spot, but that's about it. Okay? The question of timing has to do with how long do I need to condition for? Let me show you on this right here.
Okay, now let's get back to this one now. Let's not get sidetracked because I'm trying to figure out what exactly your requested remedy is going to be.
So since we believe that the plaintiffs knew or should have known and willfully did not follow the instructions as provided in the instructions that were provided and the evidence of this case of always keeping the probes in vinegar, as stated right there, store conditioned probes in white soap, they did not do that. They did not attempt to do that. They didn't do it at all. But they violated also the instruction that said, always keep the probe moist. They didn't do that as a result. They never stored it.
I know I understand what your position is factually. What's
I
your
believe it's
remedy?
willfully that our first request that the plaintiffs' causes of action against us in, I think, 6 and 7. That they be denied. Strike them. Strike that complaint with regard to those 2 causes of action. If the court is unwilling to, we have discussed inside of this motion, in other words, it's not willing to go that far, for the willful behavior of knowing what to do, how to do it. They have the instructions. They actually have the video showing Blaine Jones doing it, right? And then they didn't do that. And then they didn't store it in vinegar, which is what Blaine Jones says this is what you should be doing. They didn't do that. That there are other ones that have to do that. I would say that the easiest one is to say this. We can't test these probes for accuracy. That's what Dr. Babcock says. Therefore, the negative inference should correlate to that. There can be no inference that these probes read inaccurately. Remember, what we believe is that conditioning affects how fast it stabilizes and does not affect accuracy. Dr. Babcock's telling you, I can't tell you the accuracy of these. Therefore, I can't tell you how fast it gets to an inaccurate number because they're inaccurate. They're dry. They can't tell you accurately anything because they're dry. So is in the negative inference.
If that was important, why didn't he ask the test during the discovery time period where the initial expert disclosures were made and also rebuttal expert disclosures? During that time period, if that was a key issue, why didn't he ask to test the actual probes when you were sending the more recently produced probes to him for testing purposes? If that was a key issue, why didn't he want to test the actual probes?
We just need to see whether the conditioning, because that was the allegations that had to do with conditioning.
The probes that are at this locker that they had were all conditioned.
I know, I understand that, but if there was such a concern vis-a-vis accuracy of the probes, why didn't Dr. Babcock request to inspect the actual probes during the time period for initial expert disclosures and rebuttal expert disclosures?
So we got the plaintiff's expert report in March 24th, I believe, of this year. Okay.
Right.
But then in April, we did our rebuttal report related to this hydrazine questions, which kept coming up and said, you didn't read hydrazine, which we had to address this court. At that point in May, the end of May, we said, look, we better find out what's going on with these probes that they have there. Because we didn't even know if they still had them until my office did an inspection on March 24th, 2023. So we're not talking about a long time to wait, but it certainly comes after when the expert reports were first done. Then we would have 3 or 4 weeks. I think it was
This is a totally completely different issue, but they need to change 16.1. But go ahead. They do, as far as this disclosure time period. And the reason why I say that is this: I thought the original 16.1 made more sense as far as the staggered time periods, because now I have to deal, because at the end of the day, a lot of these rebuttals aren't rebuttals. They're not. They're new opinions, and it makes our job much easier, much more difficult. And I don't think the Supreme Court understands that. I really don't. I think they miss it. But go ahead. That's a different issue.
okay.
It brings frustration to me. But go ahead.
So, thank you, Your Honor. I appreciate that. I think I understand what you were saying, and I can't disagree with you on that.
Yeah.
Under the time constraints that we had, our expert report was due on March 24th. That's when we also received the plaintiff's expert report of Michael Motley for the first time, so we can see what he's talking about. He's going after warning labels, in this case saying they're all inadequate. I took his deposition in May, which is after our rebuttal report is already done. To which I sit down and say to him, what are you saying to me are the problems with the instructions? Tell me what you mean. What instruction with regard to moist don't you understand? Tell me why this is bad. Tell me why we didn't do it adequately. Tell me why this instruction is good. I did that. That was in May. We asked for a review of those in the beginning, like June 1st. I think I've already told that to the court. We didn't get a chance to inspect them until June 9th. These dates are flying. It's not like I was waiting months, and I think that you probably could come after me and say, Mr. Rasmussen, you had all the time in the world to do this, and I don't think that's true. We didn't close a discovery. Actually, it was June 6th is when we saw them. June 9th was the close of discovery. Okay? And I'm not suggesting that the plaintiffs hid them from us or wasn't going to give us a chance to look at them, but what they didn't do is they never kept them moist for the whole 2 years that they had them. We had no idea that they weren't keeping them moist. We don't know that. We assumed they did. They had the instructions. We assume that they're doing everything. We don't know if they're moist or not until then. And then when we get out there and see them, we took photos, we sent them to Dr. Babcock. He came back and said, no, I can't even do anything with these. These are rendered. They are spoiled. They're capable of being tested. So I think the negative inference here is that, look, you had them in your control. You know you're supposed to keep them moist.
Would you have had, I mean, if you went to find this information out 3 days prior to the close of discovery, why then?
Oh, do you know how fast it takes for us to test it? We take a testing solution, we put the probe into it, it'll give us a reading like that. It takes about 2 minutes to do it. And it doesn't matter who does it. We can literally show it on the screen to Dr. Babcock in a photo. Here it is. I've got a solution here at negative 150. It doesn't matter, whatever it is. I'm just checking an accuracy. Are these accurate? In other words, if my test solution says negative 150 and I put the probe in and it says negative 150, they're accurate. That's all I needed to do. I just had to turn it on. My associate attorney could do that. Dr. Babcock can look at the result. Oh, I know the test solution is negative 150. I know, I see the picture of the screen. It says negative 150. We're right on. These are accurate probes. I could not do that.
Okay.
And the reason I couldn't do it is not because we weren't willing to do that, not able to do that, couldn't do it. Because Dr. Babcock's told us they've been rendered incapable. I'm going to believe my expert, a chemist, before I believe somebody else. I think we should rely on experts and people that know what they're doing in the industry, who have experience in doing that, not people that are advocating for someone else. So I've provided to the court the case law on this. If you want me to go through the case law, I can, but I don't know that it's important because I think I've cited it correctly as to everything that we have to do there. But I will put it on the record.
I mean, I'm familiar with.
I know you are. That's why I don't really want to go over it.
Johnny Ribeiro. I'm familiar with
Yes.
Bass Davis and the whole litany of the spoliation cases. In fact, we even went through and we looked at all the spoliation cases from the plaintiff's perspective and the defense perspective to get an idea as to how the court handles spoliation cases and if there's a difference.
So you're intimately familiar, Your Honor. You've seen my case law that I've cited in my motion. If I misstated something and didn't cite it the correct way, I would hope the court would say, Mr. Rasmussen, I don't agree with you. But I think we're there when I have cited the cases that are there that have to do with this sort of stuff. We'll get back to
The Zenith case, and we can go on. There's more.
well, we started out with Young versus Ribeiro. You just said that one. We
Yeah, John.
cited to that. We also did Foster versus Dingwall. That's a 2010 case.
Bahina, there's another one.
Yes. We have the cases here that said, we did do the Blue Martini case. I understand it does not have a Nevada reference. The court may not want to look at that because of what you said earlier. It is an unpublished disposition denying a petition for a writ of mandamus. I get that. But there's enough there that says, look, if it's in your custody and control, you need to maintain it. It's your evidence to maintain. You know the instructions because you're literally suing us because you think we have bad instructions. And then we go out there to look at it. We could have tested it right there that minute. Okay? Now, the plaintiff may have said, no, you're not allowed to. You didn't ask for that. You just wanted to look at them. We would have then moved with the special master. Hey, now that we've seen them, we think that they're going to be something that can be worked with. We don't know that. Dr. Babcock would have told us that. Hey, do you think we can be used? He looked at him and said, no. I couldn't tell you if they can be inspected or tested or not. I'm not a chemist.
What does the manufacturer think?
So the manufacturer, Carl Savaggio, looked at the same stuff, but he's not a chemist. But he looked at them and says they're dry, they can never be used. He's the president of Milwaukee. He's also the operations manager for Hanna. He says they can't be tested. He says if they're dry, they're dyed.
Okay.
Okay? You know, if that's the hang of it, that we're going to do that, then I can tell you that in 26 other cases, we'll ask to review these and go out there and test them all, even though we think they will show nothing. But we can do that, and we'll make sure we're prepared for that with all the other cases. By the way, we know that that's going to be an issue, it sounds like. It's whether or not you tested them or not. And if that's what you're going to rule on, so you need to just still test them, even though a chemist says you don't need to.
I'll be really candid with you. This case is a products liability case involving allegations of inadequate warning. And I'm trying to figure out how that precludes you from defending the inadequate warning case, because I'm quite sure you have an expert on that specific issue, right?
But the result is this. What they're saying is these meters, because of the way that we talked about how to condition them, okay, their expert says this wasn't adequate. These instructions that you see up on the board, up on the screen, those are not adequate. Okay? As a result of them not being adequate, people got hurt. Okay. But what if they read accurately? What if they did everything right and they were accurate? Well, it's still inadequate. Well, but if they read adequately and we gave it your water with an accurate reading, what were we supposed to do? What was the product supposed to read accurately, right? That's what you bought the machine, the instrument for, is to measure an accurate reading. Well, conditioning really hasn't got to do that. It's about time, how long it takes for it to come together. Well, you can look for that. We can put it in a test solution and say, okay, how long did it take? Which is what my testing was about. I'm not going back to that motion, but this is what we were trying to do, is check on those things. We can't on the ones that were actually at the facility. Thank you, Your Honor.
Thank you.